Did you petition the probate court to be in charge of an estate? Are you administering an estate without the guidance of an attorney? Have you been granted full authority of an estate? If so, you need to be familiar with a document called Notice of Proposed Action. Failure to familiarize yourself with this document can be costly and time-consuming. Hello again, this is real estate broker Daryl Williams with Win-Win Realtors here in Southern California. In this program, we assist personal representatives and attorneys with real property that's going through the probate process. Selling real property that's in the probate court here in the state of California requires either court supervision or the use of a notice of proposed action. If you have been granted full authority under the Independent Administration of Estates Act, you are allowed to sell real property without court supervision. However, you must properly use the notice of proposed action. On the notice of proposed action, beneficiaries and interested parties may consent, may object, or take no action. If no one objects to the proposed action, you would not need court approval in order to sell estate real property. If you had limited authority, court approval would be required in order to sell real property, and an overbid process would then be in place. The notice of proposed action can protect the personal representative against lawsuits from beneficiaries and other interested parties. There is another document called Waiver of Notice of Proposed Action, which will allow the personal representative to sell the property without court approval. Who is entitled to the notice? Heirs in law, beneficiaries in a will, and other interested parties requesting a notice. A common scenario is the selling of estate real property. When selling estate real property, the personal representative must send out the notice of proposed action 15 days prior to the date of the proposed action. Beneficiaries and interested parties must respond to the notice within 15 days or deal with the decision of the personal representative. If objections are made during the 15-day waiting period, then a court order will be required in order to proceed with the proposed action. If no objections are made, then the proposed action will be allowed to proceed. When you are represented by an attorney, the attorney will handle the notice of proposed action. If you are not represented by an attorney, you as the PR will need to handle the notice of proposed action, and you need to be very familiar with this document so you can avoid complications in this case. If you've gotten value out of this video, don't forget to like, share, and subscribe. And if you have any questions for me, my contact information is in the description. I'm Daryl Williams. Thanks for watching Win-Win Realtors TV, and I'll see you in the next video. This presentation has been for information purposes only, and it should not be construed as legal advice in any shape, form, or fashion. I am not an attorney. If you need an attorney, please consult one. If you do not know any attorneys, I'll be more than glad to give you a referral.